Jones. You're still going to be in our jail for a limited time before they transfer you to TDC. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if you tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now. Number 24, DCCR 2431. You're charged with, let's see, are we going on just, what counts are we going on that one?
Which case?
That's the unauthorized use of a vehicle.
Well, it was just the first paragraph. First paragraph should be fine.
So the state jail.
Yes, ma'am. Well, I'm showing only one paragraph.
So it is that. Okay, gotcha. So you're charged in 24 DCCR 2431 with the state jail felony offense of unauthorized use of a vehicle. And that's from October 15th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with. And then finally, in cause number 25 BCCR 1352, you're charged with the first degree felony offense of aggravated robbery from September 18th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with. I have here on the tablet in all three of those cases documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0523, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 2431, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 1352, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. These 3 cases will run concurrently, which means together at the same time. I'm going to hand you in all 3 of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Wilkerson. Now, let me tell you one more thing, Mr. Jones. You're still going to be in our jail for a limited time before they transfer you to TDC. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if you tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now. But honestly, we're ready to get you out of our jail because you've been such a menace to everyone out there with what you're doing. And let me tell you, when you get to TDC, you think you're funny, you're young, you're not going to get away with what you're getting away with here in TDC. There's some bigger, badder, worse people than you there. And also, if you think you're going to make parole by acting how you've been acting, you're not. I would bet money today that you're going to be in our prisons for 35 years because you don't know how to behave. Prove me wrong, and that would be great. If you figure it out and start learning how to mature and act like a normal human being like the rest of us, but my money is on you not doing that. So I wish you'd prove me wrong, because everybody that has to deal with you, they're just doing their job, and you're putting them through all that. Is there a victim impact statement?
No, Judge.
Go back with the bailiff.
Thank you.
Thank you.
Thank you.
Thank you. I'm going to need you guys to sign that, please. Good morning. Are you Kaylin Billups?
Yes, ma'am.
And this is cause number 19-32315. Ms. Billups was previously in court on probation for a deferred probation for aggravated assault with a deadly weapon. And there's a motion to revoke. We were previously here and she entered pleas of true to counts 1, 2, 4, and 5 in that motion. And I've received the updated report. Have you both had an opportunity to review that report?
Yes, sure. Yes, sure, we have. And after speaking with probation and Mr. Kimler, I think we have an agreement
Okay,
to follow the
the recommendation.
recommendation of safe figure. That's correct, Your Honor.
Okay, so
We need to resolve the misdemeanor, which hopefully I can do that this morning.
all right, Ms. Phillips, in cause 19-32315, I'm going to find that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. However, probation has made a recommendation, and it sounds like everyone is willing to work with you to give you an opportunity to be successful. And so I'm going to go along with that recommendation and continue you on probation. Order that as a condition of your probation, you enter and successfully complete the SAFE program, the special needs SAFE. That will give you the treatments you need, hopefully, for everything going on, mental health, drug abuse, whatever it is, so that when you get out, you can be successful and you'll have the tools to be successful. It's important that you do everything you're supposed to, make the best out of that treatment. When you get out, you will have aftercare that will also be a condition of your probation. So it's important that you do all of that as well. Do you understand?
Yes.
If not, and you violate again, I can assure you, if you're back in here on another motion, things will not be this easy. Do you understand?
I understand.
Okay, this was not an agreement. You do have some limited rights to appeal. Mr. Kimler will hand that to you. I wish you the best of luck, ma'am. You can go back with the bailiff, and thank you, ma'am. Mr. Kimler?
Yes, I'm sorry.
Good morning, sir. Are you Jorge Del Fiero? And Mr. Del Fiero, in cause number 25, DCCR 0892, you're charged with third-degree felony offense of assault family violence by impeding breath or circulation from January 31st of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler.
Yeah.
This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, including a no contact with the complaining witness. Do you understand?
Yes.
You have every right to reject that offer and go to trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial? All right, we'll get that done. And Ms. French, is there any reason to believe that that offer would change in any way?
It's gone now.
Okay,
Just to be clear, Your Honor, it's a condition of his bond. There is a no contact with the victim. Is that correct?
there should be.
Yeah. Contact. All right.
Yeah, so it's important that, if it isn't already, I'm sure it is, a condition of your bond is that you have absolutely no contact or communication with Amelia Adams.
Yes, ma'am.
That obviously means in-person contact, but it also means sending messages through other people or social media or anything like that.
To be sure a child knows, so there has to be some communication or visitation.
So there are apps you can use, like the Family Wizard, where you don't have to have actual contact, but you communicate through an app that saves everything. It kind of protects both of you, so that all communication is saved on that app. It shows it's only about what's going on with the child, pick up, drop off, school stuff, whatever it is. My suggestion would be that you use that, unless you have some third party, a parent or grandparent or somebody to help. But it's a nice thing to use anyway, really just to protect yourself, so that you are, and it's kind of handy, everything that's going on with the child. You have something, you can put it on that. If she has something that's going on, she can put it on that, so you can both see what's happening with your child, doctor's appointments, things like that.
So to be clear, our communication via the app is not a violation of the bond condition.
Correct, as long as it is only about the child. Now, if you're on that app and you send something that is not about the
Yes.
child, it's saved and we're going to know about it. So that's the best way, and the way that I would definitely approve for you to have contact only with regard to the child.
Yes, ma'am.
Okay.
You understand?
I do want to make sure you understand that after today, I will not accept this plea agreement. It sounds like it's off the table. So if you change your mind later and want to enter a plea of guilty, it would either be open to the court or to some other agreement. You understand?
Yes.
Okay, we'll see you back at trial then. Stay in touch with Mr. Kimbler.